Okay, next, first of all, I apologize for, I'm a mumbler, and I apologize to our court reporter for not being able to hear me all the time, so please don't follow my example and speak directly into the mic, and so we can be sure to get the proceedings down. At this point, we will turn to Mr. Kobayashi, who represents Speaker Emeritus Say, and you have 20 minutes. Thank you.
Thank you, Chairman Rhodes. I'm Bert Kobayashi. My associate, Maria Wang, is sitting next to me, and my client, Speaker Emeritus. I welcome the opportunity to come before you and summarize our position, and I hope to do the best job I can for Emeritus Speaker Say. Even though the documents supporting our position were not required to be turned in until the 17th of this month, we have prepared and submitted, along with declarations, our position in detail, and made it available to each of the members of the committee. I thought it made more sense to have the documents before you rather than to submit it after my presentation. We have a couple extra copies if anybody should want to pick that up. In summary, I hope to present the facts and the law that are supported by my presentation to address the issue as to whether Representative Say is qualified voter of the 20th Representative District as required by Article 3, Section 6 of the Hawaii State Constitution. Now, I'd like to address a couple of points, first of all, that were brought up by Mr. Collins. Mr. Collins is a very polished and articulate speaker, but keep in mind that he is not under oath. Nothing that he has said is evidence, and that he is here for a purpose and to represent his clients. He's also here for the purpose of seeking to discredit Mr. Say. Otherwise, why would he get into issues as to whether he had a little too much to drink one night or not? I mean, it's totally irrelevant, strictly there to try and color the issues. The other thing is that he was asked whether or not the city clerk had any decision-making in terms of residency. And in terms of that, I would call your attention, and I have cited it in the documents that I present. The issues and rules with regards to residency are set forth in Hawaii Revised Statute, Section 11-13. And it specifically states that final determination of residency shall be made by the KRS 1141 and through 1144. So if you wanted a specific answer as to the role of the city clerk, it's spelled out in the Hawaii Revised Statutes. I have included in my presentation the provisions from the Hawaii Constitution and also from the Hawaii Revised Statutes, which Representative Say was required to abide by and which govern the consideration of this committee. I think there is probably two things that stand out in terms of what I think should be considered. First of all, the Hawaii Revised Statutes that applies to residency has not changed a single word since 1985. So the law that has been in effect has been in effect since 1985 right through the present day. And the other point I'd like to point out or bring up is what the facts are as confirmed by the declarations of Representative Say and his wife. First of all, he claims as his residence the property located on 10th Avenue in the 20th Representative District. Mr. Say's parents lived in the 20th Representative District, and he grew up in that district. He and his wife purchased the 10th Avenue home in or about 1980. He has been registered to vote in the 20th Representative District without interruption since 1980. Starting in 1995, he acknowledges that his wife, Cora, and his two sons began providing live-in care to Cora's father and mother, who lived at the Star Road address, which has been referenced by Mr. Collins. And they became the caregivers for her parents until they passed away. In that time period and up to the present date, Cora Say and the two boys have made their home at the Star Road address. That has not been denied, that's acknowledged. Up until 2006, she had her residence at the 10th Avenue address. When it was questioned, her residency was confirmed by the city clerk. An appeal was then filed against her and against Mr. Say. She did not want to get into a public debate. She decided not to fight the appeal. Mr. Say did fight the appeal, and he did prevail. At the present time, both his wife and sons are residents of the 26th Representative District. Yeah. Okay. At the present time, it is Cora's and the boys' plans to continue to live at the Star Road address until such time as the boys make their decisions as to what they're going to do in terms of moving out and what is to happen to the house. At the present time, one of the boys has purchased a home in that representative district. Mr. Say has always said that he spends substantial time at the house at the 25th district. He acknowledges that he eats most of his meals there when he is not busy with the legislature. It is for the purpose of spending time with his wife and his sons. He sometimes sleeps at that address when it is more convenient for his schedule, particularly when he is in session. However, he has submitted a declaration to the effect that no matter what time he gets to the house, over the course of time, he spends most of his sleeping hours at the home in 10th Avenue. It is his intention, and has always been his intention, to make that his home and his permanent residence. At the present time, Representative Say and his wife are in fact currently renovating the home in the 10th Avenue. As to intention, which is what Representative Evans talked about, since buying the home and becoming a registered voter in that district, it has been his intention to return there whenever he is absent, and he has never intended to establish a permanent dwelling place in any district outside of the 20th Representative District. Now, these facts and his residency have been challenged 3 times before the city clerk, and that started in 2006. With regards to each one of the challenges, the law that I cited has remained the same, and in each time, based on the facts that I've said, the city clerk has found that Mr. Say is a resident within the 20th district. It was appealed on 2 occasions, and in both occasions, the appeals sustained the position of Mr. Say. I think it would be important to look at what the applicable law is. And the following section, which is HRS 1113, which I've highlighted in my presentation, is what contains the general rules for establishing residency. I think it is important, and I've said this before, that these rules have not changed since 1985. For the purposes of this rule, in determining a residency, a person may treat himself separate from his spouse's resident. In other words, it is not conclusive that he does not reside at a particular place, even though his wife is a resident of another address or another district. The residency of a person is a place in which that person's habitation is fixed, and to which, whenever the person is absent, the person has the intention to return. A person does not gain residence in any precinct into which the person comes without the present intention of establishing the person's permanent dwelling place within such precinct. If a person resides with a person's family in one place and does business in another, the former is the person's place of residence, but any person having a family who establishes the person's dwelling place other than with the person's family, with the intention of remaining there, shall be considered a residence where the person has established such dwelling place. So that if his family lives somewhere else or his wife lives somewhere else, for whatever the purposes might be, as in this case where the situation was initiated because of the need for live-in care for Cora's parents, then that does not change the residence. And as I stated before, this section does say that final determination of residence shall be made by the clerk. subject to appeal to the Board of Registration under Part 3 of this chapter. In closing, I would say, based on the facts that you have, the fact that the law has not changed since 1985, and the fact that this committee is subject to the Constitution and the Hawaii Revised Statutes, we would respectfully request that Mr. Say be confirmed as being validly seated in this legislature. I am open to any questions that you have.
Thank you very much. Members, questions? Excuse me, Majority Leader.
Mr. Kobayashi, is the respondent planning to submit supplemental evidence after today's hearing?
We will submit supplemental evidence if you feel it's necessary. As of this date, we do not intend to submit supplemental evidence. I would point out that a supplemental declaration was filed yesterday on confirming the fact that one of the boys had purchased a home and is in the process of moving out, though still hanging around at the house on Star Road.
Okay, thank you. We did receive that supplemental declaration. I have a question on the two original declarations that were submitted by Representative Say and Mrs. Say. And I'm asking this because the declaration refers to some timing issues. For example, paragraph 23 says, "I am currently renovating my 1822 10th Avenue home." The declarations are not dated. Can you...
Okay, the declarations are effective as of the day we presented them. I believe that it was in the last 2 days. So that those declarations would be current. You can consider as of today.
Can you resubmit declarations that are dated?
We will.
Okay,
I apologize for that omission.
Thank you. So I did have a question on the renovation. What is the start date of the renovation?
At this point, we will make a note and submit that information. My understanding is that we are not presenting witnesses, and to tell you the truth, I did not ask Representative Say for the details on the improvements, but I will submit that no later than Monday morning.
Okay, I think it's important for the committee to be able to consider the date, the start date, as well as the estimated time.
We'll give you the details on that and the scope of the improvements.
Okay, thank you very much.
Incidentally, Monday is a holiday, so if you want to wait till Tuesday, that's fine.
Appreciate it very much.
Not that some of us won't
We'll
be
do
here,
it Tuesday.
Members, any other questions? Okay, I have some of which are quite similar to the ones I asked the opposing counsel, but you heard the conversation between the two of us about at what point does intention become, how long can intention be enough to maintain the residence? At some point you just don't live there. What's your opinion on that?
I have not seen any case law that would indicate a time period. I would assume that if one intends to return to what he considers to be his home, even though he is spending time in another district, then until that intention changes, the law just asks for intention. It does not specify a time period. If Mr. Say's intention should change, then he would not be entitled to claim the residency in the 20th.
So you dispute Mr. Collins' assertion that at some point intention isn't really no longer relevant?
I don't think it makes logical sense to have a time period on one's intentions. Everybody's intentions differ. It doesn't mean they change over time.
Okay. Do you believe that, obviously Speaker Emeritus Say has been reelected, was elected, I think, the first time in 1976, and has been reelected several times after this residency controversy has arisen. Do you think there's any legal significance to that? In other words,
The only thing that I would say, and I don't think it's legal significance, but I would say that the overwhelming majority of the people in his district don't think that that's an issue or disagree with the position that Mr. Collins has taken. Otherwise, he wouldn't have been elected.
But you don't think that it actually changes. You don't think it actually changes the question of qualification per se. It doesn't factor into that.
I do not believe it does. In response to the point raised by Representative Psyche, we have no problems with looking at past history on this because we believe that this issue has come up before. The law hasn't changed. The facts haven't changed. Why should the decision change, particularly when it was placed in the hands of the city clerk? For that reason, we would think that the past history is supportive of the position of Mr. Say.
Okay. So I know that one of the statutes says that it doesn't. You don't have to establish residence with your spouse, and there's a multitude of reasons why someone or a couple would not have the same address. But is that a? I mean, if that is the situation here, there's no dispute about that, I guess, at this point.
We don't dispute that at all.
Okay. So but your contention is that has no legal significance either. That the statute says what it says, and that's it.
That's our position. The statute says what it says. The other thing in this situation is I think that growing up in Hawaii, caring for parents is a big issue. I think it's understandable that his wife and boys moved out to be caregivers. I don't think that's unreasonable. I also think it's reasonable that he spends a lot of time there having dinner and staying with the family when he can. But that does not change intent.
Okay. So then, again, you heard my conversation with Mr. Collins about their position, the petitioner's position, possibly being that Speaker Emeritus Say has never lived at the 10th Avenue address. What's your
If that's an issue, we need to overcome that with evidence. I don't think there's a big problem.
Okay, so
he has lived at that residence.
That's
the move to Star Road didn't come until 1995 when the parents needed the care.
Okay.
And since then, he has said, and like Representative Psyche said, the declaration is current as of now. He continues to sleep there most of the time. He may not be there during the daylight hours a lot or when he's being observed.
Well, and that raises another question that I was asked a couple of days ago. Well, are you going to basically send someone out to Speaker Emeritus's house and just watch what's going on? I guess my question is, what, in your opinion, would that do any good? And is there any legal significance to having a private eye follow your client around?
If you get back to look at the law, and the law is couched in terms of intention, there's no way a private eye or observation is going to have any impact on a person's intention. I would also say that, the challenges started, at least for Mr. Say, in 2006. Had there been a need or desire to change the law, it could have been changed. The law has remained exactly as it is since 1985. And I think that speaks for the fact that because there are so many variables, because there are so many different things that could happen, that people have been comfortable and satisfied with the law. If that's what the law is, and that's what Mr. Say has abided by, then I don't see why he does not meet the requirements of residency, as has been confirmed by the city clerk and the two appellate bodies.
Okay. Members, any other questions? Representative Evans.
I want to get back to this rule on determining residency.
She's not going to be able to hear.
Sorry. I want to get back to the rule for determining residency where it states, I'm reading HRS 11-13. It says, for the purpose of this title, there can be only one residence for an individual, but in determining residency, a person may treat oneself separate from the person's spouse. My question is, why do we need to have a declaration from Cora Say as to her own person in terms of where she resides and why she resides there when this isn't about the spouse?
This has come up since 2006. Probably this is the seventh time. I think the reason why we included Cora's statement was to give as much information as we could. I agree with you that it's not relevant to the issue of intention. It was just to give a more complete picture.
I'm saddened by it. I'm personally saddened by the fact we have to ask the spouse to get involved and make some statements and stuff, because really, I believe this committee should be focused on, where Representative Say resides and what his intentions are, but to drag the family into it, I think is real unfortunate.
We would agree with that, and as I stated in the past, when the city clerk ruled in their favor, the appeal was against both Cora and against Representative Say. And at that point, I think her thinking was as yours is, and she decided she had enough of having to get into the public eye, and for that reason, she did not fight the appeal.
Okay. Thank you.
Thanks, members. Any other questions? Representative Fukumoto Chang, excuse me.
Thank you. Does Representative Say claim a homeowner's exemption on his property at the 10th Avenue home?
I don't know that. I can get you that information, and we'll submit it Tuesday.
Okay, thank you. And I think maybe in addition to that, I'd like to know what's required to claim the homeowner's exemption. I can do some research on that myself too, but that would be helpful just to make sure that if he does qualify for that, then okay, great. Then in theory, perhaps that's also a residency thing. Thank you.
Okay. Anyone else? All right, I have a little farther to go. So again, similar to the question I asked Mr. Collins about the interconnectedness of the fact pattern that feeds into the questions that have been into the challenges. Do you see there being any qualitative difference between the facts that we need to determine this case that in comparison to the other challenges that were brought at the at the clerk's office and
No, I do not.
So your position is that basically all the same facts. There's different legal decisions, but it's basically based on all the same facts.
We did some research on that, and the way that it comes out is that this committee is governed by the Constitution, and you are also governed by the Hawaii Revised Statutes. The statute hasn't changed, so I don't think the condition or the questions changed.
Okay, but the related question is one that Representative Saiki brought up in terms of what factual information should this committee be looking at in terms of how far back we look? Is your contention that we should only look back to election day this last year, or should we be looking at as a legal matter, we should be looking at the whole 8 years?
If I had my preference, and I'm not trying to add work, I think that the whole 8 years speaks very well for what's happened, how the law has been interpreted, and I think that is the best picture you can look at.
But as a legal matter, do you believe that we're required to look at the 8 years?
I do not believe that you're required to.
But we think we only need to look back to the beginning of this election cycle.
You can do that if you wish, as far as I'm concerned. I did not see anything that required you to go beyond that.
Okay. All right. Any other question, members? Well, let me just hang on just 1 second. Okay, thank you all for being here, for your presentations. We will adjourn for the day, but as I mentioned at the beginning of the hearing, we will be looking at the evidence and assessing what you guys have told us today, and we'll be drafting a report hopefully in the not too distant future, and there will be another public meeting where we discuss, debate, and vote on what that report should look like, and there will be at least 48 hours notice as per the rule contained in Speaker Suki's memo, and we will notice that as soon as we have decided when that's going to be. So thank you all for being here, and have a good afternoon and a long weekend.